The Foreign Intelligence Surveillance Act, the role of checks and balances in protecting Americans' privacy rights. There are few rights that are more fundamental to our democracy than the right to privacy. And there are few powers that are more intrusive or more dangerous than the government's ability to conduct surveillance on its citizens. The conflict between this right and these powers go to the very core of who we are as a nation. For more than 30 years, we've relied on the Foreign Intelligence Surveillance Act to strike the appropriate balance between the government's need to protect our citizens from foreign attack and our citizens' right to be free from unreasonable searches and seizures. The heart of that bargain was that government could indeed use its awesome power to conduct surveillance, but subject to independent court review, although a somewhat cursory and secret court review. 6 years ago, the administration unilaterally chose to engage in warrantless surveillance of American citizens without court review. And 6 weeks ago, when the scheme appeared to be breaking down, the administration insisted that we immediately pass a law they had drafted for us that essentially transferred the power of independent review from the courts to the Attorney General. And that was done without hearings. We're here today to consider whether that was the appropriate course of action and what this Congress can do to restore the proper balance. What we've learned over the last 6 weeks does not give this chairman much cause for comfort. First, we've learned that the administration wrote their bill so broadly and loosely that it permits the government to intercept any and all electronic communications from United States citizens to anyone even thought to be abroad at the time. This would include reporters, elected officials, and political enemies of the administration, for example. Second, we've learned that also because of the broad manner in which the administration drafted its bill, the new government power is not even limited to electronic surveillance. It could apply to business records, library files, personal mail, and even domestic searches of our homes, as long as the foreign person was somehow implicated. Third, we've learned that even after weeks of negotiations and months of promises, we still have no meaningful oversight either of the old warrantless surveillance program or the new legislation signed in August. The Senate's subpoenas continue to be ignored, and the House may be on a similar collision course. The right to privacy is too important to be sacrificed in a last-minute rush before a congressional recess, which is what happened. The need for national consensus in our efforts to track down terrorists and foil their plots is too important to ignore the constructive concerns of the Congress and the courts. We on this committee are ready and willing to work with the administration, but they need to show us that they are ready to fix this broken law and ready to truly join forces in common cause against terror. Our system of democracy demands no less, and I am confident that the Committee on the Judiciary in the House of Representatives can accomplish these complex aims. And I'm pleased now to recognize the distinguished ranking member of the Judiciary Committee, Lamar Smith of Texas.
Thank you, Mr. Chairman.